Okay, you can be seated.
You got to close the curtain.
Of course. I'm supposed to do that before I open my mouth. FAWCETT versus GAINEY.
If it may please the court, my name is Edward Emmerich, and I'm here on behalf of the appellant Frances Marie FAWCETT, aka Frances Marie GAINEY. This appellate case has been brought in order to challenge some parts of the final judgment entered by the trial court, notably the marital nature of Yardarm Liquors, Inc., a business that the parties operated together at the least, if not owned, during the time of their marriage. We'll also be covering some other issues with the equitable distribution of the final judgment and attorney's fees. As we have so many issues to cover, I'd like to kind of jump right into the legal issues in this matter.
Let me ask you one thing before you do that. In the introduction part of your brief, you made some reference about a life insurance requirement, but then you didn't make any arguments about it in the brief itself. Is there a life insurance argument in this appeal or no?
No, Your Honor.
Okay.
The issues we'd like to cover, notably the Yardarm Liquors, Inc. business, start with the court's finding that that business is wholly non-marital. The standard of review here, there's been some dispute about in the briefs. We feel that there's no need for the court to disturb the findings of fact of the trial court and simply go with de novo review. As a matter of law, a determination of a piece of property as marital or non-marital should be reviewed de novo. In this case, essentially what we've done is presented two arguments for the court to substitute for the findings of fact in this case. The very base of our argument is that the court put too much weight in the finding that the physical stock shares were never transferred from mother to son and his wife in this case.
Was there ever evidence of any type of purchase and sale agreement as to those?
There was
stock
record
shares?
evidence that there was a purchase agreement that was refuted.
Physically entered into evidence or just oral testimony?
Just oral testimony.
What about any evidence of stock transfer, evidence by stock certificates or substituting names on stock certificates?
No, Your Honor, there was no evidence of physical stock transfer.
And the trial court could choose not to believe that oral testimony, correct?
That's right, Your Honor.
So we can't make any ruling based on whether or not that occurred because it was for the trial judge to judge the credibility of that testimony, correct?
That's correct, Your Honor. It's our position that that as a matter of law, that physical transfer of stock is not dispositive as to who actually owned this business. And we presented some case law in the second part of our argument showing that in certain circumstances, when one person holds the stock, they don't necessarily have to have physical possession of the stock certificates. For instance, if you were to buy a stock on the stock market, you wouldn't and then go and sell it, you wouldn't have to mail physical stock certificates to your broker or to the person that's the eventual owner.
Well, but you would agree that's persuasive evidence, but perhaps not conclusive evidence, but it's certainly persuasive evidence of ownership. And in a lot of cases, I mean, I have an account with a brokerage firm, and if it's in my name alone, then isn't that at least pretty good evidence that it's a non-marital asset, assuming I'm married, that if it's in my name alone, that it's a non-marital.
Unless there were evidence presented of commingling of the assets or marital assets entering into that account, or as is the case here, there's some kind of evidence of that account being used as security for another account in conjunction with some other things.
Didn't your own expert, when questioned about this, he couldn't conclude that this was a marital asset? I believe it's on page 427 of the transcript. I mean, didn't your own expert wasn't able to conclude that this was a marital asset?
The expert was not able to conclude because it is, and that's further evidence that this is a question of law rather than a question of fact. The legality of ownership in this case is what we're seeking to determine. The court, using the findings of fact as they were, and ending up using mainly the failure of the mother to physically transfer the stock shares, found that this asset was non-marital. In this particular case, there may be a situation where we don't have enough of a finding of fact or explanation on the record for meaningful appellate review. However, it is our position, and we've presented two separate arguments, evidence of purchase and evidence of gift, in the record to give the court the ability to make a determination on a de novo review as a matter of law, considering the facts and evidence presented, that this property was in fact marital. The evidence of purchase in this case comes from the timeline. There was the testimony from appellant here, but really the timeline is what provides more persuasive evidence. In 1997, from the testimony of appellee took full control of the business. He was in control of everything, I believe is a direct quote. In January of 1999, the first shares were executed to him and his wife, appellant. In between that time, according to the testimony of appellant, she was made aware that there was some kind of purchase agreement, that there was a bill of sale, and that they were to begin purchasing agreement.
So that's her testimony or the appellee's?
That was her testimony. Her
Well,
testimony.
we don't, you've got to base your facts in the light most favorable to the appellee, correct? So you can't argue to us that we should make a different decision because we should believe what your client said. You've got to argue to us, here are the facts in the light most favorable to the husband, and here's why we still win.
Yes, Your Honor. Okay, so the husband claimed that there was no purchase.
So for our purposes, we have to assume
We
there was
assume
no
that there
purchase
was no
agreement.
purchase. Okay, so we skip down to the next part even. It is possible that this property was owned through gift. Appellant brought this up. It was preserved for appeal through her motion for rehearing and clarification. She cited a couple cases that discussed commingling and even used the term gift in the physical motion for rehearing and clarification. As well, throughout the transcript, you'll find arguments of commingling. In order to have commingling, you have to have a situation where a property that's non-marital is mixed with a property that is marital. In this case, and even more persuasive here based on the case law, the possession of the business, the running of the business, the credit cards only being in Yardarm's name, paying the separate business, the marital business, paying those credit card debts, the lack of invoices, for transfers made, substantial transfers, hundreds of thousands of dollars a year in some circumstances, cause for this there to be evidence of gift as a matter of law. The appellee had the ability to sell this property. He collected all the profits from this property, and those are undisputed. In this situation, the parties actually put the property up, the business itself, up for sale, and that's further evidence that the business was physically owned by appellant and appellee, or at least appellant. If the court is
He's
to find,
running the business. How does him putting it up for sale indicate that he owns the business and he's not doing it just in his role as running the business?
well, if as he's gone forward in taking all of the profits, every profit that came from Yardarm Inc., as he has held himself out as the business owner, with the cross collateralization, in conjunction, all of these things, along with him selling the business, we don't have any record evidence that he is going to, the appellee was actually going to retain all of the profit from the sale, if that's what you're referring to. However, in conjunction with the 7 years of evidence that the marital family benefited exclusively from the sales from Yard Arm Liquors Inc., that they took out loans in the name of Yard Arm Liquors Inc. for personal expenses, that they used marital funds to pay off some of those loans and credit card debt. All of these things together show that there was physical ownership of the business, even though it was the physical stocks were never transferred. He had possession, and you can, as referenced in my brief, there's several cases that involve this situation where one person doesn't have physical custody of the stocks, but since they had all of the benefit of the stock, since they were aware of the value of the stock, which can be shown by the putting it up for sale, received all the stock dividends, etc. They owned the stock. The court was found that they owned it. And in situations where someone else actually reaped the benefits of the stock, the court found that they didn't own it, that the person that was claiming inter vivos gift did not actually own it, where the person claiming inter vivos gift didn't actually receive the benefits or didn't know the value.
And are there cases in which the trial court finds that they are not commingled or not owned, and an appellate court has reversed the trial court, or are these ones where the appellate court has affirmed the trial court in finding that there was commingling or there was ownership?
Well, these are actually probate cases and not family cases that determine inter vivos gift, so they're persuasive and not controlling.
And are they ones where the appellate court reversed the trial court for not finding the transfer, or affirmed the trial court
I believe
determining there were transfers?
I believe that one of them is a reversal, and the rest of them are affirmations. There are 4 cases cited regarding gift. And there's opinions rendered in each of them, and I can't tell from my brief which ones were reversals and which ones were affirmations, but there is...
Makes a difference, don't you think? It's a whole lot different affirming what a trial judge has done, saying there's sufficient evidence for that, and you asking us to reverse the trial judge for not doing it.
Yes, Your Honor, but in this matter with the de novo review, we feel that a review of the facts and application of the law, and this is valid case law, and in fact, one of these cases that has to do with stock registration is from the 5th District Court of Appeal. We feel that should be sufficient for the court to move forward on the evidence of ownership, as ownership is a matter of law as well as a legal conclusion, based on the facts found by the court. And then after that, the commingling of the business of the non-marital business with the marital business. The next thing I'd like to get into, if you don't have any further questions on the initial issue, is commingling of the business post death of Jean GAINEY, who was the record owner of the business. And upon her death, the court found the physical stock shares were actually transferred. From October 1st, on her death, when the stock shares transferred, to the date of filing on January 17th of the next year, $161,500 was passed from PAMET, the marital business, to the non-marital business. In addition to that, all of the other evidence of commingling of funds between the non-marital business and the marital business still continue to exist. There's cross-collateralization. The PAMET continued to pay credit card payments in the amount of about $500 a month. The non-marital business was propping up, to a certain extent, the marital business. The final judgment anticipated this argument and found that it wasn't the case that commingling could have occurred in that period of time. However, it is our position that as a matter of law, at least a portion of the non-marital business or a component of the non-marital business should be found to have been commingled, as the assets that we cannot distinguish from other assets that were moved from the marital business to the non-marital business. Not only does that cause commingling, because we can't separate them out, the court could not trace those assets, but once they get into the non-marital business, but the value of those assets, the value of that money going into the non-marital business is what actually gives the stock value.
Didn't the husband's expert purport to be able to trace all those things?
He didn't, I believe the record was not that he purported to trace it. He argued or testified, he testified that the accountants were able to reconcile the funds. However, with no transfer of goods, even though the accountants can make your books look right, that doesn't mean that there's no asset sharing, almost, to the extent that the cash that was moved from one business to the other was made. And also to the extent that those assets have moved around. You know, once that money moves from the marital business to the non-marital business, then it can go, we have no evidence of where it went after that, whether it was used to improve the non-marital business, whether it was used for purchase of goods. There's no invoices, there's no receipts. So even though those can be reconciled on books at the end of the year, as most businesses do, they just provide the numbers, and at the end of the year their accountant does the math and adds it up so that it looks right and the IRS doesn't come calling.
You're down to about 3.5 minutes if you want to save some time for rebuttal.
I'd like to take about 1.5 minutes to cover the attorney's fees portion, skipping over the non-marital jewelry and dissipation and furniture. In this case, the court didn't award the appellant attorney's fees after the dissolution of marriage. The court was presented with evidence that at that time appellant had somewhere in the vicinity of $53,000 in attorney's fees, just in charging liens, plus loans from her parents in the amount of around $20,000. After they awarded the non-marital business, in this case Yardarm, to the husband, he had approximately double the assets of appellant.
Is that why you say in your reply brief that the former husband left the marriage with $537,000 more in assets than the former wife?
Yes, Your Honor.
That's based on the Yardarm decision. That is not based on anything else.
That's right. Yes, Your Honor. The outside of the Yardarm decision, if this court were to reverse or remand that decision, it would be based on the disparity in incomes alone. Honestly, the equitable distribution award at that point would be pretty close. Thank you, Your Honor.
I think, Counsel, you got about 2.5 minutes.
May it please the court, my name is Barbara Egan. I represent the appellee, the former husband in this case. I believe, Your Honors, as to issue 1, the inter vivos gift argument and the purchase by the parties argument, I think we pretty much laid that out within our brief, and there doesn't appear to be a lot more to be said about that. When we turn to the point in time after the death of Mrs. Gainey, where the Yardarm was clearly devised to her son, as the judge found in lower court proceedings, there's no evidence whatsoever that there was any enhancement in value or any other factor that would cause this to perhaps be looked at as something other than a non-marital asset because of the non-familial gift to by devise. As to the attorney's fees, my client paid $20,000 of her attorney's fees on the record. No further fees were awarded because of the equality of their positions and some of the other equities that the court looked at. And it's our position that that was a correct decision within the discretion of the trial court. And we ask that this court affirm the judgment in its entirety.
Let me ask you a question about attorneys.
Absolutely.
Both parties have filed motions for appellate attorney's fees.
Correct, Your
Claiming
Honor.
need and ability to pay.
Correct, Your Honor.
Should we determine that based on where the parties were at the time of the final judgment, or is this one of those situations where there ought to be conditional grants and the trial court can determine whether they each have a need and an ability to pay?
I believe it's the conditional grant scenario, Your Honor, that this court would determine my client entitled to fees, but it would have to go back to the trial court for all of the findings, need, ability, etc.
All right, and let me ask you a question on the jewelry issue.
Yes, Your Honor.
As I understand it, the equitable distribution included jewelry to the wife valued at $10,000.
Correct, Your Honor.
As I understand, looking at the transcript, that appears to include an engagement ring that at some point the parties seem to indicate is non-marital property. Is that correct?
That was a little bit confusing.
First of all, is the engagement ring non-marital? Is there an issue about that?
I don't think there's an issue. I think it would be non-marital if he gave it to her prior to their marriage.
All right, and so the question then becomes, if the award of $10,000 to her included the value of the engagement ring, that should have been deducted out for equitable distribution purposes, correct?
I don't think it was included. The evidence that the trial court reviewed was the financial statement of the husband. And in that financial statement, he said there was $10,000 of marital jewelry and then an engagement ring at a certain price.
Didn't he testify that that could be lower? That was just an estimate?
I don't recall. I believe you're correct, Your Honor.
Okay, so can the court just go by the financial affidavit?
I think so, Your Honor. I don't see that. I saw no authority that would not be competent evidence in a judicial.
Same with furniture also?
Yes, Your Honor. I'm not sure it would be the same as to
I'm
real
looking-
property.
I'm looking at the testimony of the husband,
Okay.
and it says, the question was, I noticed on your financial affidavit that you list about $10,000 worth of jewelry. Can you describe what that is? Yes, the diamond ring for the wedding ring. Question, the diamond ring, is that something you bought for her as an engagement ring? Yes. How much do you believe that how much of the $10,000 consists of the diamond ring? Answer, not being an expert, but maybe $3,500, $3,000 to $4,000. So that seems to be an acknowledgement by your client that the $10,000 figure he's using includes the engagement ring, doesn't it?
Yes, it does, Your Honor.
That
It
would be
conflicts with
improper
his
if it was
financial.
indeed an engagement ring, because it would be non-marital, right?
Yes, Your Honor. If there's nothing, we would ask that you affirm the judgment, and thank you.
In rebuttal, Your Honor, Your Honors, I'd just like to state that as to the commingling occurring post-death of Gene Gainey, I'd also like to point the court to the fact that the parties to this case owned the commercial property that the business worked out of. And that commercial property was found to be marital. And the business never paid rent to the commercial property, which is, in my opinion, further evidence of ownership, if not commingling through the passage of the funds from one business to the other and operating two businesses as one. In reference to attorney's fees at the appellate level that was brought up, it would be our position that, based on the Canacaris case, that the court should look to the positions of the party at the time of dissolution of marriage and their ability to obtain competent legal counsel in order to maintain an appeal. Actually, the statute on attorney's fees states that appellate review is one part of the entitlement to attorney's fees based on when the court from time to time may consider an award of attorney's fees based on the financial resources of the parties. Here, my client is in substantial debt. She has $537,000 in the least, less in assets, and not to mention that this asset that she has less than the appellee is an income-producing asset, and he has the ability to make loans against this asset and to obtain credit to make purchases through the business, whether it be personal expenses or business expenses that actually decrease his personal expenses. It's also important to note that Jean Gainey gave up all of her interest in the business in 2005, and pursuant to that same pursuant to a 2000 corporate action, the parties had the ability to do whatever they wanted essentially on the business, to create new shares, to transact business on behalf of the business, et cetera. And then in 2005, when Jean Gainey resigned all of her positions, she had no ability to control the business, and that goes back to the inter vivos gift portion. Lastly, I just want to say that I appreciate the court's time, and we would ask that you reverse the findings with regard to attorney's fees, reverse the findings with regard to, or change the findings with regard to the jewelry and the marital furnishings, reverse and or remand the findings with regard to the non-marital nature of Yardarm Liquors, Inc., as we do feel that if the court cannot actually reverse this position as a matter of law, that it would be better for meaningful appellate review if there was a further finding of fact on the individual issues of the case. Thank you.
Thank you, counsel.
Thank you.
Court will be in recess.